Obtaining a domestic violence restraining order in California is a pretty simple thing to do. There's no fee for the application. The application itself is a judicial counsel form, that's DV 100, and a factual declaration must accompany that alleges what specifically happened, what abuse specifically happened, and why the person requesting the restraining order needs protection from the other party that is going to be the restrained party. The process on the temporary restraining order, which is the initial restraining order, is an ex parte process, meaning that if someone goes and applies for a restraining order, the person that may or may not be restrained by it, depending on what the judge decides to do, doesn't even know that they've applied necessarily, and they certainly don't get a hearing. The judge will determine, after reading only the allegations contained within the domestic violence restraining order application, if a TRO, a temporary restraining order, should issue. For 21 to 25 days thereafter, that restraining order will be in effect, and the restrained party does not have the opportunity necessarily to be heard or make any changes to that, barring some emergent or exigent circumstance. There will be a hearing, there will be due process, but that typically comes 3 weeks plus thereafter. The problem with a restraining order for the restrained party at that juncture is that if they lived with the person that filed the restraining order, they will very likely be kicked out of their home and will not be able to go within 100 yards of that person. They will not be able to contact them for any reason. Same with children. If there are children involved, very often one party will request a restraining order to also protect the children, meaning that the other person, the parent, can't have communication with their children, can't see their children, so they may end up outside of the house. They may end up without any contact with their family whatsoever for at least 3 weeks. Domestic violence in California, because this must be factually pled at the temporary stage and then proven when there's a hearing on the permanent restraining order, is very liberal, meaning that it's defined in 2 places at the California Family Code, section 6203 and 6320. It's much more than just physical violence, which is what a lot of people think. Domestic violence in California, or what's known as abuse, can be anything from stalking, harassment, or even breaching the peace of the other person. These are all subjective concepts, and the court has broad discretion based upon the facts that are alleged and the relative circumstances to decide whether or not too many emails or too many phone calls or too many attempts to go to somebody's home or place of business constitutes domestic violence, abuse, stalking, harassment, and so on. One must be very careful then in their conduct with other people in a qualifying relationship where domestic violence could be alleged, in that if one believes that they're doing the right thing, they're trying to salvage a relationship, they're trying to rekindle a romance, whatever the case may be, the other side may constitute that as some form of harassment and file a restraining order. So it's very important to be careful in one's actions, and it's also very important to be aware of the types and the broad discretion that the court is given to determine abuse and determine whether or not a restraining order is going to issue. If you're a victim of domestic violence, you definitely should do something about it. What should you do? The first thing that comes to my mind is, what kind of domestic violence are we talking about? If you're the victim of some physical incident, some immediate threat, some threat to your life or the safety of others, you should call 911. You shouldn't count on a piece of paper and an eventual court hearing to protect you. So the first thing you have to ask yourself is, am I in immediate danger? And the ones that I'm responsible for protecting in immediate danger, that should be the threshold question. When in doubt, call the police, get law enforcement involvement. The police have the ability to arrest, the police have the ability to remove people from the home, at least temporarily, and particularly if someone's arrested, and the police can request what's known as an emergency protective order, where you can get an emergency TRO, temporary restraining order, for 5 days, giving you a chance to then go to court and seek a domestic violence restraining order in the manner that I've already spoken about. If it's a different form of domestic violence, it might just be as simple as taking proactive steps to end it, such as getting out of a relationship or trying to get out of a relationship, blocking someone on your cell phone so that they can't call you and they can't text you, blocking someone's email so that they can't continue to communicate. Sometimes people will get the message. Oftentimes they don't. If they don't, then that might be the time to take it a little bit further and ask someone to intercede, ask a lawyer to perhaps contact them, maybe their lawyer, and ask them to stop, cease and desist from the harassment, from the unwanted contact, or maybe you have to file a restraining order so that you can have the court make an order preventing that person from taking those steps. It's not an easy question because there are legitimate victims of domestic violence every day in this state, and that is a significant problem. But as I mentioned earlier, there are many people, unfortunately, that abuse the process, take advantage of the fact that it's free, take advantage of the fact that it's fairly easy, and they request restraining orders for no legitimate purpose but to get a strategic advantage. So I often will advise people, generally speaking, that you don't want to take this step. You don't want to subject yourself to the process of a restraining order and the cost of a restraining order. By that I mean attorney's fees and emotional cost if you really don't need one. If you file for a restraining order, you can expect that the other side, particularly if they retain an attorney, will be defending against it fairly vigorously because of the nature of it. There will be much involved in a proceeding before the court, an evidentiary proceeding or a trial relating to evidence, testimony, cross-examination, other witnesses that may have seen something, police officers. So it's a fairly big ordeal, and it typically starts with a relatively simple process. So again, once you've let that genie out of the bottle, you can't put it back in. It's all public record with very limited exception. So whatever you allege about that person, whatever they allege about you, whatever is said in court in a public proceeding is out there for the world to see. So you really have to think, at least initially, do I need to go this far? Is it this severe? And if it is, then absolutely you should take every measure available to you, including a domestic violence restraining order, to protect yourself and those that you need to protect. If it's something that you think you can give it an opportunity to quell, that can resolve itself, that's always the best way to go before just filing for a restraining order.